Sarah, you're on News 96.5. Go ahead.
Hi, I have 3 questions. This regards landlord-tenant. Number 1, how do I get a tenant out of a mother-in-law apartment when they refuse to pay the rent and they just kind of smile at me when I say, you must leave? That's question number 1. Question number 2, what are my parameters as a landlord if they leave items behind?
I got it.
They moved in as a couple, and the girl left quite a few items behind.
I get it, Sarah. I get it, Sarah. Question number 3 is?
His fiancée took my garage door opener. Can I charge her with theft?
Yeah. Now, Sarah, would you want them out because of non-payment of rent, or you just want them out?
I want them out for non-payment of rent.
Okay, Sarah, when you are a landlord and your tenant does not pay you rent, step number 1 always is a 3-day notice to pay rent or vacate. That 3-day notice must be properly filled out. It can be then handed to your tenant or taped to their front door. After the 3 days are over, on day number 4, you can begin legal eviction proceedings. Now, Sarah, with that said, there is a form of this 3-day notice in the Florida statutes. It looks deceptively easy, but there are all kinds of ways that you can make a mistake in filling out a 3-day notice to pay rent. Sarah, my recommendation is that you meet with my landlord-tenant attorney, Rob Solomon, in our office. He will help you prepare that 3-day notice. Now, once you evict your tenant for non-payment of rent, or your tenant leaves no matter what the circumstances are, there is another statute that deals with abandoned property. And that statute says, as I recall, Sarah, is that if that abandoned property is worth less than $250, I do believe you can do whatever you want to. You can keep it, throw it away, put it on the curb. If it's worth more than that, Sarah, then you are obligated to give your tenant notice and an opportunity to come get it, and then there's steps that you go to after that. Now, Sarah, you're talking about your tenant leaving with your garage remote control. Can you charge them with theft? Theft is a crime. Sarah, you will never, ever convince the state attorney's office to bring a criminal charge against your tenant. This is strictly a civil matter. Therefore, Sarah, your remedy would be to sue your tenant for whatever damages or deduct it from your security deposit with your tenants. Now, Sarah, good news. Rob has a landlord workshop coming up on September 6th, and your landlord, I recommend that you attend it on September 6th. You want to do that, you simply call or text Chrissy anytime, 407-808-8398. And Sarah, Rob is my landlord-tenant attorney. He's in my office right now. You can hang up with me and call 407-423-5561. That's Olsen Law Group in Orlando, 407-423-5561. Or you can always email me your question. The easiest way to do that is through our website, Lawtube.com, like YouTube, but Lawtube.com. Hey, folks, my name is Tom Olsen. The name of the show is Olsen on Law. You're listening to News 96.5.